There is detailed plan of attack. We proved that the business was in NYC and that Massa did not make the decisions as that was his written admissions. We have our path forward. A conference call is called for this Wednesday. BTW. The documentation that was presented to you the other day regarding how Massa admitted that he was not the sole decision maker was the whole ball of wax. It is absolute proof. It was clearly presented in court and was a laser beam of our attorney's focus. The facts are the facts. We are showing you the truth and we are presenting you the facts. We are taking the depositions of Mr. Massa, Mr. Eddie Huey, Bob Morello, Joe Skrapitz, and others. We are putting into the court immediately to depose them with all the documentation again, and we know what's going to happen. This is the day that they are worried about. End of the story. Depositions under oath with these documentations. You will see the documentation below and written admissions by Mr. Massa that was submitted to the court stating that he does not make the decisions. He stated in writing that Eddie Huey and the board made the decisions as that was one of his written admissions. Why is this important? It is important because that is what this judge based her decision upon. This matter came down to one thing. That one thing turned out to be who made the decisions for the company. Massa testified on the stand that he made all the decisions of the company. And we proved and verified the crux of the matter, which was who made the decisions. Massa testified on the stand that he made all the decisions of the company. We know that to be false, and he also knows that to be false. Also, we provided the court with hundreds of documents and testimony from employees like Mike DeStefano to prove that all of the business took place in New York City. The judge agreed that the business took place in New York City. It was an evidentiary hearing. We produced all the evidence at this evidentiary hearing. Massa et al. Produced 0 documents at the evidentiary hearing. Not even one document. First, we are moving immediately to dismiss the bankruptcy by exposing all of the frauds, lies, embezzlement, securities fraud. Second, we are hauling Massa, Eddie Huey, Bob Morello, Joe Skrapitz into immediate depositions where they shall be utterly exposed for all of their frauds, misdeeds, lies, etc. Third, we are bringing the massive financial restitution derivative lawsuit exposing everything. Considering what has transpired, we have no choice but to go to the nuclear option. Not that we weren't going to do it anyway, but it is obvious that it is absolutely what is required to make everyone see the light of day. As you are all aware, the evidence of their wrongdoings is overwhelming. As you are also aware, the only place of business that anyone was aware of for Gem emanated out of New York. No one knew about any Kentucky office or business location. So let us get to the facts of what we just witnessed, as the judge determined the venue was in Kentucky. BTW. We are bringing all of the overwhelming evidence, documentation, and witnesses to the FBI, Attorney General of New York, the Southern District of New York prosecutors, United States Trustee, the SEC, the federal district judge whose federal court order they violated and trampled on by the criminal Massa regime. We are taking this to American Greed, the Wall Street Journal, Bloomberg, and various other social media outlets, including the major networks. We are going to let each respective agency know that all of the evidence and documentation is being presented to all of the other agencies. It's going to be one big nuclear party. Discussion of the venue decision. The evidentiary hearing, as Mr. Massa implied in his recent email to you. The facts are Mr. Massa entered not one piece of evidence, not one document, and put nothing in evidence. The shareholders provided all of the evidence from the evidentiary hearing. Hundreds of documents were entered into evidence by us into the evidentiary hearing. The judge made the correct decision from the overwhelming evidence, documentation, witnesses that the business activities were centered in New York City. One would think that would be the natural conclusion and determination. However, it turns out there are 2 ways to decide a venue or jurisdiction of a business in a matter like this. One, where the company's business activities took place. 2, a factor which is known as the nerve center test. All of the proofs we uncovered are going to all of these agencies, and we are bringing a dismissal lawsuit and a derivative lawsuit. While she determined that the business activities obviously took place in New York City, she determined that the nerve center test was how she was going to decide this matter. See below. Fish Supreme Court upholds the nerve center test to determine a corporation's principal place of business. She was correct in applying the nerve center test, as the court determines who makes the business decisions of a corporation and where the control of the business took place. All of the evidence that was presented, written documentation and written confessions by Mr. Massa, proved irrefutable that the management team made the decisions. The management team consists of Mr. Massa, Eddie Huey, Bob Morello, Director of New York Board of Directors, as shown in the organizational chart of the PPM. They made the decisions of the corporation, and that is the crux of the matter. The decisions that were made, as per Massa in a written confession, were Massa by the board, Eddie Huey, Bob Morello, and Mr. Massa came to New York to make critical corporate decisions, should have resulted in the correct decision by the judge that New York is the nerve center of GEM. She did not. She disregarded all of the written evidence, documentation, and the confession by Massa in writing. As a matter of fact, not only did she disregard all of the written evidence, documentation, and confession by Massa in writing, she took his word on the witness stand as his testimony, completely contradicting his own written confession. She determined that the nerve center of GEM lay solely in his Mr. Massa's brains. For example, below is a shareholder communication to another shareholder. This is Patricia Gilchrist, where Massa was responding to Mrs. Gilchrist's questions in May. There is an additional email from Mr. Massa to Mr. Bob Bernard, where both of them clearly, undeniably, incontrovertibly, and indisputably shows to the world that Massa stated emphatically that he did not make the critical decisions by himself in Lexington, Kentucky. Nobody was dismissed from employment, laid off, or otherwise without an agreement by Eddie Huey and the board, unlike in the past where one person was making decisions for the company. No one person is making decisions. This was not always the case in the past. The current decision process on the matter of the significance requires meetings of the entire board with adequate legal input. We have had a board meeting, Scott. We believe we have a solution. Excerpts from Massa's email to Bob Barnard knowingly accepting Bob Barnard's investment in the email of March. In March, knowingly seeking bankruptcy by New York-based Bob Morello on March 6. Bob Barnard quote from James: "What will be explained during the meeting is why Bob Morello, chairman of the board, New York-based, and I, called a special shareholder meeting. Ensured we have been working to ensure that a shareholder vote is meaningful and valid." Massa to Bob Barnard: "As to your comment on, to Bob. Bob's comment to Gary, James already knew what he was going to do on April 5, 2019, as Massa was accepting investments from shareholders like Bob weeks after the massive regime surreptitiously sought bankruptcy on March 6, which is classic securities fraud and is confirmed by other shareholders' affidavits which will be going to the authorities. Yet Massa encouraged me to proceed and send my $5,000 in." End of quote. Massa's response to Bob Barnard quote: "I did not know a 3 times parenthesis this is a clear case of securities fraud. Massa: the decisions and recommendations come from the board, not me. How could any human being with an average IQ come to the conclusion that Mr. Massa was the sole decision-maker of GEM in light of the obscene, self-evident, clear, unambiguous, the refutable written admissions that he did not make the decisions by himself and was in fact made in the control center of New York City, where the management not only resided but net?" Below is the actual written documentation that was presented as evidence to the court. Just so you know, when Massa was asked and confronted with his own written confession and documentation and in shareholder communication and asked how he could maintain the apparent lie that he is the only one that makes the decisions and no one else, he froze and started crying on the witness stand. We are hauling them into discovery, where they will finally have to answer for their transgressions, as their evil deeds shall not escape justice, neither shall they. No one will. The law which she relied on in deciding the venue is known as the nerve center test law and is a well-known law. She was correct in applying the nerve center test. However, all of the written documentation and evidence, including the private placement memorandum which included the management organizational chart, a legal document that investors rely on, shows that the manager of the company is the board of directors and Eddie Huey and others, which investors rely on. Massa was asked about the ppm and presented with the ppm and the organizational chart and reminded that he needed to be truthful and accurate in the ppm, that the ppm must be accurate and truthful. He and his attorneys signed off that the management of the company was himself, Eddie Huey, and the board of directors and others, which means that legally he cannot make decisions by himself. Under any circumstances. We are sending out the facts and the proof. We are taking depositions of Massa, Huey, and Morello. We are moving to dismiss and the derivative suit. When you see the written admission of the key factor of the decision, you and everyone else will know this had nothing to do with the facts, evidence, law. They put no evidence, no documentation, nothing into evidence. We put hundreds of documents in and got Massa to freeze and start crying on the key question. It will infuriate everyone. We are going to the nuclear option and will discuss it in detail at the upcoming conference call. We do have a solid attack plan. The decision was wildly unreasonable, illogical, and inappropriate. Mr. DeStefano did a great job of providing testimony of the operations of the business and how it was run. He discussed the physical setup and the physical layout of the 2 floors. The judge obviously disregarded that information. It was not a mail drop. If it was a mail drop, why would Massa go visit and mail drop 7 times every month? Why would he do that to go from Lexington, Kentucky to New York to visit a mail drop box? We are taking the depositions of Mr. Massa, Mr. Eddie Huey, Mr. Bob Morello, and Mr. Joe Skrapitz and others. We are putting into the court immediately to dispose them and present them with all the documentation again and again, and we know what's going to happen. This is the day that they were worried about. The end of story. Depositions under oath with this documentation. Regarding the nerve center test issue, how could the judge dismiss all of the valid documentation? We produced all the documentation to prove that Massa did not, as he claimed, make all of the decisions. He made some decisions, but the primary decisions were made by the board, Eddie Huey with him in concert. He did not make the decisions, and he admitted that in his own writings. The judge discarded all that information and the written documentation, which is unheard of and preposterous. They are actually written confessions. The judge then stated that since Massa said, while on the stand, that he made all the decisions, she determined that the nerve center of the company is wherever Mr. Massa goes, and Mr. Massa stated that he lives in Lexington, Kentucky, and that is where he makes the decisions, contrary to the written documentation that when presented before him and the court, which subsequently caused him to begin crying after a 15-second pause upon being asked, obviously to get out of answering the question, but proving that he could not answer the question. Ultimately it means that the judge is saying that the company is in Mr. Massa's brain because he made all the decisions, even though there was an enormous amount of evidence to prove otherwise. She disregarded all the admissions and written evidence presented to her and took him at his word. So it doesn't matter if Mr. Massa in Lexington, Kentucky, or on another planet like Mars or Pluto, then it did not matter. That is where the business would be. We all know this is preposterous, and we all know this is ridiculous. Gary Nerlinger went there to testify. They asked me to come there to testify, and when I was about to get on the witness stand, the judge asked their counsel, "Do you want to cross-examine Mr. Nerlinger?" Their response was, "We do not wish to cross-examine Mr. Nerlinger." So now American Greed, the Wall Street Journal, also True Media, and the United States attorneys, the FBI, and the United States trustee, the SEC, the federal U.S. district judge, are all going to hear about this. By no means are they out of the woods. This has just begun. We are moving forward on the dismissal, showing all of the frauds and thievery. All of the proofs that we have uncovered are going to all of these agencies, and we are bringing this dismissal suit along with the derivative suit.